Buenos días. Please, headphones. Please, let's start. Headphones. Buenos días. Bienvenidos. Os voy a explicar simplemente la forma de usar la interpretación. Cuando vayáis a hablar, por favor, dadle al micro, se encenderá una luz.
Good morning. If you want to speak, please turn on the mic and make sure that the red light is on. Once you've done, please turn your mic off. I have yet another request. Whenever you are speaking, you may wish to remove your headset. Welcome to this meeting, and I hope that it will be productive for all of you. Thank you very much. Good morning and welcome. Welcome to our meeting, the meeting organized within our project. Some of you already know each other in person, and we have already met online during our previous meeting. On behalf of Metal, I do hope that the outcomes of our project will be very effective. Migration is present all over Europe. We have migrants from other European countries and from all over the world, and this is something we are going to discuss. So I would like to hand over the mic to Marek, who will be our moderator today. So Marek will present what we have planned today and will guide us from now on. Thank you.
Thank you very much. If you don't mind, I will be speaking English through both days. My name is Marek Benio. I represent European Labour Mobility Institute, which is a European think tank gathering natural persons. So we represent natural persons, not companies, not organizations, who are involved in various professional capacities in the process of posting of workers in the framework of freedom to provide services. And we will be, hopefully, together with my colleague, Dr. Marcin Kiełbasa, giving you all the help and assistance in the merits of this project when it comes especially to legal framework, legal provisions, and understanding, interpretation of legal provisions which guide us through European member states when we post workers. The very important component of this legal framework is the protection of rights of posted workers, which, however, is secondary in the rhetorics of the posting of workers, because the legal basis for the posting of workers lies in the freedom of entrepreneurs to provide services in other member states. Then they usually run the business. So for the last maybe 10 years, we had a very vivid discussion which resulted in very important changes in the legislation on the European level, which aimed at achieving more balance between the interests, economic interests of service providers and protection of employees, of workers' rights. In this project, we will be focusing on two main areas. And one is temporary work in manufacturing processes. So these are all the situations where production process in a receiving member state requires more workers, and these workers are coming from another member state, and they are hired out by temporary work agencies or companies supplying human resources, supplying manpower, supplying additional workers to production process. And the second area is agriculture, and this is especially important when it comes to seasonal workers. Both of these areas are very important from the point of view of protection of rights, because in both of these areas, we speak mainly of low qualified workers, not high-tech engineers. Of course, in the production process, there are also engineers being posted, but I think the concern of our project is mainly on low qualified workers to do simple tasks, simple jobs. This, of course, means that the issue of fair remuneration and fair working conditions, including the working time and right to holidays, is especially important. And in this group, I would like to point out a very new phenomenon, which results from the demographic changes in all over Europe, and from aging of our populations. And that is namely the lack of workers, especially low qualified workers, to do simple jobs in all of the member states. And this is now being, this gap, the demographic gap, generation demographic gap, is now being filled with third country nationals. Most of you have been participating in other projects already, and you must have seen that this is the most important problem ahead of us, to regulate and to keep up the standards of employment for third country nationals. So far, we have been focusing on labor law and social security when it comes to intra-EU mobility. The third area from the legal perspective was tax area. And these three fields are already very complicated. But now, when we talk about third country nationals, we have the fourth dimension, which is the right to entry and stay in particular member states. And this is a very complicated puzzle, because some of third country nationals have easier access to entry, to stay, and to work in some member states than in others. And also, the member states retain their autonomy within the Schengen acquis to decide who is entering their country. So how does the right to issue visa or to deny visas and other titles of legal stay and entry influence the mobility based on freedom to provide services? Because on the other side, we have and this is the conflicting side, we have the employer who legally employs third country national and who wants to provide service in another member state. And we need to ask questions. Do we need a separate visa for this third country national another visa than he already has? Or is the logic resulting from the so-called Van der Elst case followed also in the realm of the right to stay and to enter to the member states? And that logic said that the worker who is posted from another member state remains the part of the labor force, labor market of the sending member state, and only temporarily, so to speak, visits the receiving member state. So he does not compete with local workers. He does not constitute a threat to the local labor market of the receiving member state. The jurisprudence of the Tribunal of Justice is very clear about it and very constant. But the debate, the political debate now is going towards the revision of this logic when it comes to the right to enter and stay. And of course, in the background, we have the long-lasting discussion of how do we differentiate work migrants from war migrants, from war refugees? How do we know who this third country national is when it comes to the relation to a labor market, his or her relation to the labor market? Having this, defining this problem, I believe, is halfway through to succeed in solving this problem. So that's why it is very important to give the right tools to the control institutions and also non-government organizations, because the history of the European Union has shown that the civil movements and civil society does a lot of good in the places where the state is not really potent to do the right thing. And in cross-border situation, the state sometimes is powerless. And I give you a very simple example. When a Polish labor inspection is running a control, they have all the knowledge and all the intellectual capacities to determine whether the working conditions in, let's say, Germany are fulfilled or not. But they don't have the legal power, the legal legitimacy to control it. So, because they control only compliance with their national law. And there is no super European control institutions. There was a proposal or hope that ELA, the European Labour Authority, will play such function. But of course, this is not possible, because this would take away the authority to control their labor markets from the member states. And the member states retain full authority in this respect. So the poor solution, but a compromise solution, was to introduce the joint inspections of two control institutions. And I think the leader from this in this field is actually Portugal, who has run most or the biggest number of joint controls with other control institutions in the first 2 or 3 years of functioning of the European Labour Agency. European Labour Authority. So this is more or less the very vague background. And before I go into details and share the presentation, I think I would like to wrap up here the merits or the merits of our project. So we will be dealing with agriculture and manufacturing. We will be interested in the posting of workers and other forms of work mobility in these sectors, and especially in the role that temporary work agencies play in providing or securing the rights of the workers who cross borders. The special focus will be on third country nationals, even though it's not in the title of our project, but it is inevitable that we will have to solve this problem. We as Europe will have to solve this problem sooner than later. Otherwise, we will end up with a very shady economic activities where crossing borders is actually a very good shelter for them. Before I go to my presentation, I think that it would be nice to start by saying who we are as we meet here alive, and have a very short round table. Just say your name and organization, and I will also ask to do the same our online participants, just to remind ourselves who we are. Okay, shall we start from online participants? Is that a good idea? Who's there first? Anyone volunteers?
Hi. Can you hear me? Perhaps.
Yes, Martin.
Okay. So hello everybody. My name is Marcin Kiełbasa. I hope you can hear me well. Is this fine? Hopefully.
Yes.
Thank you. Now, I am PhD in law, doctor in law, but also attorney at law and a legal advisor at the European Labour Mobility Institute. So our organization, our partner organization, as well as assistant professor at the Krakow University of Economics. And I'm sorry not to be there in person, but I will turn up tomorrow morning, as I'm flying this afternoon from Krakow. Right, my flight is only this afternoon, so I will be joining you in person for tomorrow's activities. So save your arguments and your fine discussion also for tomorrow. I will be very happy to join you, and together with Marek, we will be representing in this project our Polish side, or part of the Polish side, as we also have other Polish colleagues on the project. Okay, that would be pretty much everything from me, and I wish you a great day during the discussions, but also a great day in Malaga. Thank you.
Thank you, Marcin. And I see René Maria Scott.
Hola, buenos días. Encantada de estar aquí en esta reunión.
Good morning. Thank you very much for this welcome. I am very happy to be here with you, but I'm a little bit jealous of you and of the fact that you can be together in Malaga. I actually visited Malaga on Monday. I know that the weather is beautiful, as is the city. So I am very jealous of you right now, but I'm very pleased to be able to participate in this project. And I am assisting Angel, who represents Spain in this project. So we are working together. And once again, I'm very happy to be here. Thank you.
Thank you very much. And I don't know if Grażyna Spytek-Bandurska is with us. Grażyna, are you there? Can you say a few words? If not, I think we are. This is it when it comes to online participants. Yes, I'm so glad that we are all here. Okay, let's start from our German colleagues and go round table.
Hello, good morning, everyone. I'm Natasha Shrestha, and I'm representing Life Learning Development from Germany. Thank you so much. Nice to see you all here.
Hello, good morning. I'm also from Germany, and my name is Dr. H.M. Abdul Hai. And my background is like this, which I researched from the University of Bonn, and that is international development cooperation, and also from Life Learning Development from Germany. So it's nice to meet you all here and to be in this meeting. Thank you very much.
Hello, my name is Susanne Hoff. I work for La Strade International as International Coordinator. I'm based in Amsterdam in the Netherlands. This is the third project we joined. La Strade International is a European NGO umbrella organization. We have 33 members in 24 countries. In Spain, that's Proyecto Esperanza. No, actually, they changed their name, Foundation Amaranta. And we also have ACSEM as a member, and that's our organizations that work specifically on human trafficking or the exploitation of, in particular, migrants, but also nationals. I'll leave it here.
Hello, my name is Eefje de Volder, and I'm together with my colleague from La Strada International. And my expertise is on the labor market and labor abuses, actually. So, but to know the abuses, you also need to know the rights. So it goes hand in hand. Yeah, that's it for now.
Witam wszystkich serdecznie. Grzegorz Wysocki.
Good morning. My name is Grzegorz Wysocki. I'm from Poland, from the Trade Union of Workers in Agriculture in Poland. We are one of the few organizations bringing together from agricultural companies. Poland is usually seen as a country with individual farmers. And there are more than 1 million individual farmers in Poland on paper, which is not true, because actually there are fewer people actively performing the job. It's specifically 200,000 of them. I'm here on behalf of agricultural companies represented by the state treasury and also private ones. We represent people providing services to the agricultural sector, for example, insurance and seeds and smaller service providers. In Poland, we have roughly 50 different trade union organizations associated with this trade union. In Poland, I have been taking part in projects funded by the EU and funded by Norway. I'm here with my wife, who is an advisor, and this is very convenient, I must tell you. I'm really happy to be present in this meeting. I'm keen on hearing all the interesting things from our moderator, Marek. I will have plenty of comments on what Marek is going to say, and wish everyone a pleasant meeting. Hello, my name is Aleksandra Idzikowska, and I represent the All Poland Convention of Temporary Work Agencies. We are one of 3 big organizations in Poland. I'm happy to be invited to this project. Happy to see you all. Good morning. My name is Pedro Ruiz. Hello. I am here on behalf of FICI Metal from Portugal. Hello, everyone. I am also from FICI Metal from Portugal, and my name is Mario Matus. I am a leader of this project. And I am involved in research that we conducted during this project. All the best to you all during this day. Hello, my name is Rogério Silva. I am a Secretary General for the Federation FICI Metal from Portugal. FICI Metal is the major federation in Portugal, bringing together trade unions that operate in the industry. We represent various sectors in Portugal: paper industry, machinery industry, mining industry, extraction industry, and many others. We have decided to join this project as we believe that the conclusions we can draw from our debates are very important for our country, but also for the entire European Union. After all, we are talking about people, about workers. That's all. Thank you. Hello, good morning. My name is Ángel Lozano. In this project, I represent Antonio Bustamante Foundation from Spain. I have PhD in philology, and I am responsible for research. And also I keep documents and records in our project. And for 9 years, I have been participating in projects like this one. And I think it's the 5th project dedicated to posted workers. So I believe I have quite a lot of experience in that area. I believe that posting of workers is always a current issue because laws keep changing. The socio-economic situation is also changing rapidly. In this project, my responsibility is to coordinate our work and the tasks we need to accomplish so that all the objectives are met. That includes also a chatbot that we are developing, and this is a crucial deliverable. Tomorrow, we are going to talk more about our work. You are here in my country. I'm sure we will all have nice weather. All the best to you all for the whole day. My name is Javier Redondo. I represent an association of young entrepreneurs from Castilla-La Mancha. We bring together young entrepreneurs younger than 40 years of age. This is a major association in a major region with a strong emphasis on agriculture and manufacturing. My organization represents many young businesses and business owners, and we are also a member of a European network of such similar associations of young entrepreneurs. Thank you. Hello, my name is Laura Huete. I am a head of a federation. And also, it is an association of young entrepreneurs from Castilla-La Mancha. I'm happy to be here, and I'm happy that our head introduced our organization. That's all. Thank you. Hello, my name is Natalia Mena. I work at the project development department in the same organization. I think it's a very interesting project for all of us, and the conclusions we'll be drawing from our work will be very useful for the market. Thank you.
We represent both with the Joanna Trade Union Solidarity Norway Our trade union is the biggest one in Norway. That's the member are the migrants, posted workers, and the workers that's they're working in the rotation. My background is I am the lawyer, sociologist, and economist, and I am pleasure to be here.
Dzień dobry, nazywam się Joanna Kościelna.
Hello, my name is Joanna Kościelna, and I am a vice leader of Solidarity Norway. Thank you.
Buenos días a todas y a todos. Mi nombre es Eduardo Valderrama.
Hello, good morning. Eduardo Valderrama. My background is in the healthcare industry, and I'm here on behalf of Antonio Bustamante organization. I work at the employment department, and what we do is that we coordinate job placements in the medical sector. I'm happy to be here, and I'm hoping that we'll have a very productive meeting today and tomorrow. I also work at the Antonio Bustamante Foundation. My name is Antonio Rodriguez, and I am responsible for the training section. I coordinate and prepare also tenders, and also I secure the process of simply funding. I work closely with Angel, and I'm very happy to be here. And I'm sure that we'll have plenty of time to talk together.
Thank you very much. I would like to say that we also have Danish partner who is not with us, not connected, I assume, unless you are hiding somewhere behind the screen, but I don't see them. No. So if we can now go to the legal framework, I would like Daniel to fire up the presentation, and I will briefly present the legal framework for the posting of workers. And I would like to say that this presentation has not been created overnight. It is the result of one of the previous projects, and it is quite fresh because it was released in December 2023. So I amended it only to and updated to the current situation. But as you know, during the last 4 months, there have not been any legal changes in the European law related to the posting of workers. So the presentation is up to date, I believe. The clicker does not work. Oh, thank you very much. Let me begin with a very interesting definition that my colleague from Gdańsk University in Poland proposed for the posting of workers, because this definition is wider than the narrow understanding of posting. It is sending of workers temporarily, and this is very important word, temporarily, to other EU member states to provide a prearranged service. This definition allows to understand the cross-border situation that we are dealing here with. It's the employer from one member state who has a client in another member state, and in order to serve this client, in order to deliver the service, he needs to send workers to do the job on his behalf. So the employer, figuratively speaking, stays back home, whereas his agents, employees, do the job for him in another member state. As I said, the legal background, the treaty background for this is freedom to provide services. And originally, the freedom to provide services was thought of for individual self-employed specialists who take their toolbox and go across the border to deliver the service to their customer. So imagine a self-employment enterprise, a self-employed person who does not hire any workers, who does not employ any workers, but does the job himself. This was the original idea behind the freedom to provide services. But of course, as companies grow, they start to hire people because the scale of their self-employment is growing. They have more customers they can do serve by themselves. So they hire people. And those workers who are working for a service providing company are traveling across the borders. And every time they cross the border, three questions appear. Where do we pay social security contributions for these workers? Where are they insured? In which member states? Because we only say there are no borders, internal borders in the European Union, but the reality is that each member state has the right to design their social security systems as they please. They can have low social security contributions or high social security contributions. They can have very generous benefits or very small benefits. And it is the authority of the member states to design the access to social security systems, both when it comes to paying contributions and receiving benefits. So there are borders between the systems of social security. And we have to answer the question, how do we make sure that a person who is crossing this border does not lose social security just by crossing the border? So this is one question. Another question and another area when crossing border temporarily to do work in another member state is which legal standards from labor law do we apply? Because just like in social security, member states have the authority to design their labor law in the way they want. And this is for the member states, this is very important because labor law is the most important instrument of labor policy, employment policy. So in some countries, the work time norms differ from other countries. For instance, in France, the weekly norm is 35 hours, and in Poland, it's 40 hours a week, just as a norm. Which norm do we apply to a person who goes temporarily only from Poland to France to do the job? So we need to regulate this collision of differences, of collision of different norms in labor law area. Of course, I could have taken a much easier example of the collision, which is the remuneration. Which remuneration do we apply? The sending member state or the receiving member state? And for us sitting here around this table, it is pretty obvious because we already know that the Posting of Workers Directive requires the payment of the remuneration according to the provision of the receiving member state, unless it would be more favorable for the worker to get the remuneration from the sending member state. So we have the principle of more favorable rules when we apply the remuneration principle from the Posting of Workers Directive. To give you an example, when a Romanian worker is going to Austria, he should receive an Austrian remuneration, not only because it's higher, but also because the Posting of Workers Directive requires the application of the receiving member state when it comes to the design of the remuneration, the components of the remuneration. But the same directive says that this provision about Austrian remuneration applicable may not be in confrontation with the more favorable provisions had they been in Romanian law. And of course, there are no more favorable provisions in Romanian law. But if you apply exactly the same principle the other way around, so an Austrian worker is being posted to Romania, the same principle says he should receive the Romanian remuneration, unless the Austrian remuneration rules are more favorable for him. So the heart of the directive is not pay the remuneration of the receiving member state, but pay the more favorable remuneration during the posting period. This, in a magical way, creates a convergence effect. So you always get better conditions. That's the purpose of this law. And we all know what is the practice. The practice sometimes is not going along with this purpose for many reasons that I'm not going to talk about right now, but I'm sure we will discuss them. So when Günther Verheugen, the commissioner responsible for the big extension of the European Union in the years 1999 and 2004, was convincing the citizens of all 15 member states of the European Union to extend, to welcome the new 10 member states, he was appealing to the four freedoms, four economic freedoms that are laid out in the treaty. Free movement of goods. He said you will be able to sell your used car in Poland or Slovakia or Czechia. You will be able, if you are a producer, you will be able to expand to new markets without customs. Free movement of persons was a promise to the newcomers, to the candidating states at that time. So the promise was, if you have skills, you can find a job, a better paid job, anywhere in the European Union. You don't have to work only in your member state. The freedom of establishment, of course, was addressed to the old 15 member states, because you can expand your business and build the branch of your factory in the green fields of one of the Eastern and Central European member states. And of course, free movement of capital would guarantee that any revenue and profit that you make in those countries can go back to your member state, because we are a united Europe. So the original deal was that the workers and services, if I may add, would go from the east to the west, and the goods and capital would go from the west to the east of the European Union. But at the very beginning of this deal, and I would also say that this was similar 10 years earlier when Portugal and Spain was joining European Union. This was very, very similar promise. Of course, the directions were different. So what happened in 2004 was that because of the fear that a flood of relatively cheap workers from Central and Eastern Europe would jeopardize the local labor markets in high-wage countries of the European Union, most of the member states of the old 15 have introduced the transition period for free movement of workers, which basically meant that from 2004, for 7 long years, you still needed a work permit in order to work in Germany or France. There were only 3 member states who lifted this ban on free movement of workers, and they were Sweden, the UK, and Ireland. And guess what? Over 2 million Polish workers moved permanently within the first 2 years to mainly these 3 countries. Some of them returned, but this was a huge outflow of the workforce. But at the same time, skilled workers were needed also in Germany. So what happened, because there was no transition period for freedom to provide services, the Polish companies quickly learned how to employ and post workers, because there was no limitation for posted workers. There was no work permit for posted workers, because they retain the parts of the labor market of the sending member state. And this notion of remaining the part of the labor market of the sending member state dates back to the famous judgment of Ras Portuguesa, where Portuguese workers were posted to France. And this was way before the Posting of Workers Directive demanded the remuneration of the receiving member state. So you can imagine that the Portuguese workers were receiving Portuguese remuneration, the remuneration that they would have got in Portugal when building TGV in France. TGV stations, actually, in France. So the tribunal said that they do not compete with French workers for the jobs, because their work in France is only temporary, and because they already have an employer, the employer in Portugal. And ever since then, and this was, I think, early 90s, this was the judgment of early 90s, ever since then, we continue thinking of posting workers only as temporarily carrying out work in another member state, but for an employer who runs his business in the sending member state. So they virtually remain part of the labor market of the sending member state. And this logic was okay as long as the number of posted workers was small. But during the last decade, the number of posted workers grew immensely, which is good for the common market, good for the economy, because the beneficiaries of the posting of workers and cross-border service provisions are not only the workers who get higher remuneration than they would have received for doing the same job back home, but also the customers, the service recipients, who receive the service that otherwise would not be available or would be available in 3 months from now. So the freedom to provide services helps to better allocate not the workers in the European Union, but the work in the European Union. And this is the unquestionable benefit of freedom to provide services and of posting of workers. The question if posting of workers directly safeguards the rights of the posted workers in a reasonable or sufficient way or not has been resolved by two huge changes in the legislation. One is the so-called Enforcement Directive from 2014, and another one is the revision of the Basic Directive from 2018, which changed the legal framework for posting of workers, definitely for the better of the workers, in favor of the workers, although the postulates of the social partners were going much farther than the end result. So what is posting of workers? Posting of workers is not the same as work mobility. Work mobility is when you have a graduate in Poland who cannot find a job. This is very rare now in Poland, not to find a job. You must really try not to find a job. We have very, very low unemployment rate. This is like the opposite than in Spain, I would say. But let's imagine that a person cannot find a job after school. And because he has no family yet, I mean, no own children yet, he doesn't have a mortgage, and he speaks foreign language, he goes to another member state and finds a job in a factory or in a pub in that other member state. From the very first day on, he pays taxes in the receiving member state. He spends most of the money he earns in the receiving member state, and he pays social security contributions in the receiving member state. So from the perspective of the sending member state, it's a drainage of skills. This sending member state has just lost an asset, but it's okay, it's fair, because this person exercises freedom to move as a worker. So it's part of the deal. It's part of our common market. And of course, I envy him because I didn't do it when I was young. I came back from my Tempus program, which was an older brother of Erasmus program, instead of just getting a job in Italy, UK, or wherever I studied, Belgium. So I say it with envy, but I don't judge this person. This is the right that every worker has in the European Union to find a better employer, a better employment in another member state. It's really good for the common market. But from the perspective of the sending member state, and I'm not crying now over Poland, who lost 2 million souls in 2004, but I'm now crying about Bulgaria and Romania, who are highly depopulated in the working age group. there are really people leaving these two countries on a massive scale. So by the end of the day, this person, when they initially leave the country, they say, okay, I will try in another member state, and if I succeed, I will return home, I will build my own business there, and I will have a capital for start. But after a while, and it's a process, it's not a one-day decision. After a while, they are being treated well in the receiving member states. They get promoted, usually at the time when they say they're a boss that they're going home. They get promoted. They build their own business there. They bring their girlfriend or boyfriend there, or they find a girlfriend or boyfriend in the receiving member state. And in no time, you will see that they move their habitats, their place of living, their center of life interests to the receiving member state. And as I said, it's okay. They will still be coming back for Christmas to their country, but they are, economically speaking, part of another member state. There is a different way of migration, and that's a temporary migration, which is based on the posting of workers. So the same person finds a job at a local company in their sending member state, but this local company is using another freedom from the service, and that is the freedom to provide services, another freedom from the treaty, sorry. And that is the freedom to provide services. So his employer sends him to a receiving member state and only to do the job. And this person is in a very similar situation to worker number one, because he earns more than he would have earned back home for doing exactly the same work. But his return home is written down in the contract as opposed to worker one. So after completing the job, he's coming back home with higher remuneration. Also, he has more incentive not to spend his entire remuneration in the receiving member state, because the purchasing power of his remuneration is much higher when he spends the money home. This way of migration we call posting of workers. And the posting of workers is still a minor phenomenon compared to work migration. Employment migration is 10 times bigger in the European Union, but it's not controversial at all. I mean, the only controversy is the skill drainage that I mentioned, whereas posting of workers continues to be the subject of very vivid discussions both by experts and stakeholders and social partners. When it comes to legal framework of the European Union, we have to realize that European law requires special understanding, because not only because we have so many languages in which this law is translated, but also because even if we translate the same word into many languages, the meaning of this word in the local legislation can be different. And I give you the very simple example of the word worker or employee. And when you translate it, it's easily translatable to other languages. But when you look at this as a legal notion, it will have different meaning in different member states. And to give you the Polish example, we have this very famous and very popular civil type contract, whereby the labor code basically doesn't apply to this civil contract. And it's growing in popularity. Well, I would say 10 years ago, it was growing in popularity because the labor law was not applicable to this contract, and you could still have the job done. But nowadays, I see more and more young people who do not want to enter the labor contract because this civil type contract gives them more space for life, let them be more independent than the employment contract. And Professor Safian, who is the judge of the Court of Justice of the European Union, says that with so many different legal cultures in the European Union, it would be impossible to rely only on the words, only on the wording of the legislation. So more than in our national legislations, we have to rely on the interpretation of the purpose that is behind the European legislation. And this is the reason why when you look at the directives or regulations, the secondary law of the European Union, you will see that the preamble to the act is much more extensive than the act itself. The preamble has 50, 60 points, whereas the text is only 2-3 paragraphs. Well, 5-6 now, paragraphs. The reason for that is that the European legislator gives the explanation to national legislations what was the purpose of this act. In national legislation, we usually find it in the reasoning for the act when it is a draft only. So the basic provision that we are interested in the treaty is Article 56. As I said, this is the basic ground for posting of workers. And if you notice, it doesn't say anything about posting. It says that within the framework of the provision set out below, restrictions to freedom to provide services within the European Union shall be prohibited in respect to nationals of member states who are established in a member state other than that of the person for whom the service is intended. So the service provider is in one member state, the service recipient is in another member state, and the governments of the receiving member states are not allowed to give any barriers or to prohibit the provision of service when the service provider is from another member state. This breaks down to freedom to provide services, which is, however, not unlimited. The freedom to provide services is limited by Service Directive, which gives explanation, but mainly for the self-employed service providers, what can be imposed on the service providers. For instance, if you are a dentist, or if you're an engineer, or if you're a psychiatrist, can you provide your services in another member state where the standards for dentists, engineers, or psychiatrists are different? And for that, we have the system of recognition of diplomas, recognition of qualifications, which is based in the so-called IMI, Internal Market Information System, which was originally created for the recognition of diplomas, for the recognition of qualifications. Now it allows the control institutions or qualification institutions to ask a partner institution, in a liaison institution in another member state, whether the conditions are met that we expect the dentists to have, for instance. So this was one. Well, I wouldn't say barrier, because barrier has a pejorative meaning, but it's an restriction on service provision, but restriction which is justified by the standards that we need to achieve. Another restriction, and this is the area that we are dealing with, is the restriction resulting from the directive on the posting of workers, because the treaty allows and the directive allows to limit the freedom to provide services when this limitation is justified by protection of workers' rights. And the posting of workers directives, I should say, are all about the protection of the rights of posted workers. Or so I thought when I was young. Because during the political debate, it was so obvious that the purpose of these limitations and restrictions is not to pay higher remuneration to foreign workers. The purpose is not to allow cheap labor force doing our job in our member states. And this is called protectionism. And there is a difference between protection of workers' rights, posted workers' rights, and protectionism, which is aimed at the protection of our workers' jobs. And indeed, when I look at it now, when I grew up a little bit, and also when the role of Poland in the European Union has changed, because for the last 2 years, we are now one of the major receiving member states, receiving the Ukrainian citizens, so third country nationals, but we see now this different perspective. And indeed, it is in the best interests of the nationals of a given member state not to allow foreign workers to do the jobs for cheaper, for lower remuneration. Because if we do this, we will soon be out of jobs. So I'm trying to convince you that these two values are not really conflicting. They are not in conflict. They are complementary to each other. We protect the number of jobs for our own citizens, so we protect them against foreign citizens, foreign meaning also citizens of other member states of the European Union, which is not allowed, but I'm talking about axiology now. But we also do this by making sure that if there are foreign workers, they receive fair treatment. They receive equal treatment to our workers. So they can compete with our workers, but only with the skills and not with the costs, not with the remuneration. And this is a very wise approach. I must say that this is an approach that should rather put the partners at the table on a common ground. But what you've all observed, and I was also observing it for the last 10 years, this was actually a huge battle, not between the member states, oh no, but between the social partners. Posting of Workers Directive does exactly this. It demands no lower standards for employees from other member states temporarily doing the work in the receiving member state than our own nationals. So when you cross the border, you need to resolve problems in 3 areas: which labor law applies, which social security applies, and where do we pay taxes. And there is also a very important actor here who could be interested in resolving these dilemmas in their own favor. And those are the member states, the governments. Because from the government perspective, this is not, this is very important where taxes go. We would all prefer that the taxes from the workers who work temporarily in our member state would go to our tax revenue. They would build our kindergartens and hospitals, and not the kindergartens and hospitals in the sending member states. And here, we just have to ask ourselves, what is fair? What is just? Because the posted worker, if he's properly posted, he does not bring his family. Remember the worker number 1, the migrant worker? Eventually, he builds a family in the receiving member state, in his new member state, new state of living. So his children will go to the kindergarten in the receiving member state. He would be using the health infrastructure and health services in the receiving member state. But this is not the case in case of the posted worker. Luckily, we don't have to go into this kind of rhetoric because we have a very automatic way of dealing with taxes, very mechanical way of dealing with taxes. And on the European level, there are no EU law provisions related to income tax of posted workers. But each member state has bilateral agreements on avoiding double taxation with all other member states. So there is no European law, but there are bilateral agreements in international law, which are based more or less on the same principles. And the most important principle is the principle of half a year. So if you stay and work more than 183 days in a given member state, in a given country, then you should pay taxes on your income in that country, also on the income that you received in another country. So this is quite a simple mechanical way of resolving this problem. We don't have to go into the discussion of what is fair for the member state. And it's quite a wise provision. The problem is that you may plan not to exceed 183 days, but then you get an extra job, extra assignment, and by the end of the year, it turns out that you have to recuperate the taxes from one member state and pay those taxes, of course, according to the rules of another member state, to another member state tax revenue. But I want to say that this is the simplest way of dealing with the collisions that were invented. It's much more complicated when it comes to labor law and social security, because in these two areas, we have two different legislative techniques, and European law does intervene here. So for social security, we have coordination of legislations. And for labor law, we have harmonization of labor law standards, I should say. Let's start with Social Security. The starting point is that the member state may design their Social Security system as they want, and the European provision says that we have to get rid of the collision by pointing out only one legislation applicable at a time. So it is very important that we do not build any patchworks here. We determine which legislation is applicable to a person who crosses the border, and we apply this legislation in its entirety. And the very important factor here is that it is not the choice of the parties, it is not the choice of the insured person in which country they want to be insured. It is not the choice of the employer in which country they want to pay lower Social Security contributions. It is the algorithm, the very mechanical, established upfront algorithm, which works like in Harry Potter, there was this hat, the tiara of joining the Gryffindor or other houses, other colleges. And it works on similar basis, but not randomly. There is an algorithm, and there are conditions that if you fulfill them, you will fall into correct Social Security system. The biggest civilization achievement of the coordination is that it will never leave you without the protection, because it works automatically. Even if you don't have the portable document A1 issued, the protection follows you across the borders. You are subject, even against your will, you are subject of one or another member state's Social Security system. This is very important, because what would the freedom to move freely in Europe mean if by crossing a border you would lose Social Security protection? That would mean that it's only a partial provision. So the coordination has 2 or 3 purposes. The first purpose is that there should be no double coverage. No double coverage, meaning no double contributions, no contributions paid for the same period to 2 systems, but also that you are not allowed to draw Social Security benefits from 2 systems at the same time. And that's one effect of the coordination. But much more important effect of the coordination is that when you cross the borders, you do not lose the rights that you have already acquired in your Social Security system. You do not lose the rights that you are in course of acquisition of. So you do not interrupt your Social Security story. And in order to picture how important it was for the establishment of the common market, I would only say that the first regulation on the coordination of Social Security system was coordination number 3. This was the 3rd legal act of secondary law of the European Union after the treaty, which was issued. It was so important to make sure that Social Security follows you when you cross borders. When it comes to labor law, the starting point is the same. So you have, sorry, one more remark about Social Security. because I didn't answer the question which legislation is applicable when you cross borders. The basic principle says it's called in Latin lex loci laboris, and it says that you should pay contributions in the member states where you work. The place of work should determine the place where you pay social security contributions, and it's quite logical. It's okay. It's better than the place of residence, because the contributions are related to remuneration. They are usually the secondary to remuneration. So it's a very wise general principle. But in case of posting of workers, we have the situation where we have a worker of whom we know that he will cross this border twice. He will go to another member state, do the job for a limited period of time. How limited, it is not determined in law, but we know that the job is temporary, and after completing the job, he will return to his original social security system. So if we know from the start that he will be changing the system and he will return to his own system, why should we bother with fragmentation of his social security record, which for the purpose of determining his pension in 20 years from now will be troublesome? Of course, there are mechanisms which allow for adding up social security periods in different member states, but this is for migrant workers. For posted workers, the lawgiver said that it is best not to change the social security system. So there is a value behind being constantly or continuously insured in one member state. The value is that in some member states, the systems are designed in the way that you need some kind of initial insurance period before the insurance starts working, before you are actually protected. You are covered from day one, but you are protected only when the risk occurs after half a year. This goes for unemployment in most of the member states. But this goes also for short-term social security benefits, like sickness benefits. When you get a job and you get immediately sick, you will not receive sickness benefits in some member states. You have to work for at least a month. And for posted workers, working for a month is already quite a long assignment. So the coordination says that in such situation, when we know that this person is returning back home, let him continue to be the subject of legislation number one. So the history, the insurance history is not shredded for this person. The second principle, which goes away from the lex loci laboris a little bit, is designed for workers who are not temporarily, but constantly throughout their careers, but throughout entire career, they are performing work in 2 or more member states. So imagine professions like international transport drivers. Where is their place of work? To determine lex loci laboris. Where do they work? I asked this question to the Polish transport trade union representative, Mr. Kucharski, and he said, well, my place of work is in the cabin, in my truck. This is my place of work. The problem is that the truck does not have its legislation on social security. So we have to artificially pin him to one legislation, even though his place of work is moving with him across different legislations. And the Social Security Coordination finds a solution for this and says that it's much more important to have single legislation than to change legislation every few hours. Because imagine someone going from Netherlands to France and or to Germany better, and crossing Belgium and Luxembourg. He would be subject to 4 social security systems in one day had we applied Lex Loci Laboris. So for highly mobile workers, I call them this way, highly mobile workers, international tourist guides, for instance, when they cross borders also. Or my favorite example is the elevator serviceman, the man who services elevators. The elevators are moving, but they are not crossing borders. But they are installed in different places in the European Union. So in order to repair or service the elevator, you need to send a person there. And they need to be insured in one member state only. Of course, the big question is which member state it is. And there is an algorithm which says that this usually should be the member state of your residence. But if you do not perform 25% at least of your working time in the country of your residence, this would be the legislation where your employer has their office, their headquarters. So it's either the place of residence or the place of employer's office, registered office. And of course, if we have such provision, you can imagine that since the member states have different level of social security contributions, and this social security contribution adds to the indirect costs of labor, there is an inclination that if you have highly labor-intensive kind of enterprise, you need to find the cheapest possible social security system and insure your highly mobile workers there. And this is why there are so many international transport companies in Cyprus. It's not because in Cyprus they have so many kilometers of highways. And it's not because in Cyprus they drive those trucks, but the headquarters of the international transport company is in the country where social security contributions are relatively low. And because none of the drivers performs more than 25% of their work in the place of residence, they are all insured in Cyprus, where they never have even been. Is this a scam? Is this honest? Is this the kind of side effects that we didn't want to be there? Because, of course, this company has even bigger headquarters somewhere in Belgium, Germany, the Netherlands, I don't know. But they build a letterbox company through which they employ and insure all their drivers, all their workers. I was thinking if this or similar abuse of the system, because letterbox companies certainly are abuse of the system, although they are not illegal, because letterbox company is an execution of the freedom of establishment, one of the treaty for treaty freedoms. So can we apply this to agriculture, or can we apply this to manufacturing and the posting of workers in manufacturing? Yes, of course. If we establish our temporary work agency in a country with low social security contributions and hire out workers from that country, from that branch. So yes, letterbox companies as temporary work agencies are also possible. But why they are not as apparent as in case of transportation? Well, because in the case of temporary work agencies, we have additional standards which require full equal treatment of the hired out workers and the workers in the receiving member state who are also hired out. And this full equal treatment means that it is not useful to establish a letterbox temporary work agency. And I will finish, if you let me, this introduction into the legal framework with the probably most complicated issue, namely the labor law. In the labor law, we have the principle of harmonization. So the starting point is exactly the same as in Social Security. You, dear member state, may have labor codes as you please. You may even refrain from having labor codes and establish all your rules on employment in the form of collective agreements. And indeed, there are couple of Nordic countries, Scandinavian countries and Nordic countries, which basically don't have labor codes. Or if they have them, they never apply them because majority of the legislation is done by the social partners, which makes the labor code redundant. There are countries like Poland where this is completely opposite. There are collective agreements, labor collective agreements, but they have they play really marginal role in really shaping the labor contracts and working conditions and conditions of employment. So the harmonization principle says that no matter what is your legislative technique, no matter what is your labor law and how it is established, we all agree that there are some minimum standards of employment that have to be obeyed. And those minimum standards are listed in the social chart. They are more developed than in the form of directives. So as in Social Security, the coordination was based on regulation, which has direct applicability, but does not influence the shape of the systems, does not influence the systems. In the labor code, we have directives which need to be implemented in the legislation of the member states. And the starting point is that you can have regulations as you please, as long as they meet minimum standards. This way, we are not judging the member states by how beautifully they translated the directives into their legislation and their national languages, but we judge the member states by the effects of this legislation. So, for instance, if there is a minimum standard of equal pay for the same work for men and women, we do not look into the legislation. How did you write this provision? But we look at the gender pay gap. How high is the gender pay gap? Why didn't you get rid of it yet? And apparently we need more European regulation, well, directives on this, because recently we had the directive on transparency of remuneration, which lack of leads to retaining the gender pay gap. This is usually how we achieve the minimum standards of employment in the member states, but not in the case of posting of workers. And this is the most beautiful thing that we could have invented in the European Union. We do not have minimum standards of employment for posted workers. Instead, we've constructed a method of stealing the minimum standards from the receiving member states' legislation. So the directive reads as follows: Dear governments, you have to force the employer who is not established in your country, who is established in another member state, that if this employer posts workers to your country, he will make sure, this employer will make sure that the basic provisions, the minimum standards in the 9 areas of labor law from your legislation are applied to his workers. So we steal the standards from the receiving member state, and on top of that, we put the favorability principle. So we say, if you post a Polish worker to Germany, use the German standards in remuneration, holidays, work time, unless the Polish standards are better. Then use the Polish standards. That's favorability principle. This is very nice because we don't need to build a European law for migrant workers, European law for mobile workers. We use the national law in order to receive the effect of convergence. And that's the legal framework for it. And of course, because it is so intelligent and so sophisticated, it also is very complicated. And the complication, very simple complication, starts from day one when you start to compare which provision is more favorable for the worker. And who decides about it? You cannot ask the worker, because he may have different preferences than his than the favorability principle. And I give you an example. I have a colleague with whom I worked for many years who hates holidays. I mean, he does not, he cannot rest. He loves work. And he enjoys his work. And if you were doing his job, you would also enjoy his work. So he doesn't take holidays. And he doesn't want holidays. So for him, more favorable provision would be, okay, let's skip the holidays for the next year, and after 5 years, okay, I will take a leave and go around the world for half a year and you will be paying my remuneration. But the law says you cannot postpone your refreshments. You cannot postpone your rest, your holidays, because you will get too tired. And it's the law that says what is better for the worker, even though in his private opinion, it would be better to postpone it. No, you have to use the holidays during the year that you have the right to them. And I think it's a plausible example that you should not always ask the worker. I have a much better, much more realistic example. In late 90s, we have abandoned in Poland the supplement to remuneration for hazardous conditions. All over Poland, in highly hazardous works, in steel plants, for instance, they've been receiving supplements for hazardous conditions. This is basically the money paid to you because you lose your health when doing your job. Instead, the law said now you have to provide the working conditions that prevent these hazardous conditions. There is no legal remuneration for working in hazardous conditions, the obligation of employer is to invest this money into protective measures rather. And what did the workers do? Well, of course, they went on strike. They opposed because they lost a lot of money without realizing that this money is paid for losing health, basically. So in their private opinion, it would have been better for them to get more money than to work in safer working conditions. Why? Because this money was years ago, it was implemented in the law in the first place. It shouldn't be there. You should never pay the worker for losing their health and extra money, because you will find a worker who will do this extra hazardous job, lose their health, and do it for the money. I have more abstract examples, like for instance, in the test that I do to my students, we have to invent a lot of false answers to the right questions. And one of the false answers I've invented was that a breastfeeding mother can give up her 2 hours or 1 hour break, which is payable, for the extra remuneration, a supplement for non-breastfeeding, non-breastfeeding supplement. Yeah, I see on your face that this is outrageous. So you would pass my test because it's a false answer. But I can imagine a person who would take the money in order, to earn more and refrain from breastfeeding. Of course, it's an abstract, absurd example. I have managed to show you 5 of my 100 slides. The other one are just more, go more into detail. One last remark about the labor law. What surprised me after the revision of the directive was that the so-called long-term posting has not become an issue, neither in control procedures nor for the interpretation, and also there are no pleadings in the courts for applying extensive catalog of employment conditions. The reason for that may be because the assignments in posting of workers are not really longer than 6 months, than 12 months in most cases. So this has not become an issue. Okay, let me pause here then, because I think this is the time for the break. And after the break, we will discuss the information deficiencies in the posting of workers. So what kind of information is missing or hard to get? And we will focus on filling these gaps in our project. And I'm, of course, open to the discussion. Actually, Mr. Wysocki wanted to challenge me, and I'm open for that. And of course, if you feel I said something out of the box, please intervene too. But let's do it after the break. Okay. Thank you very much. Coffee break. would like to comment on this, and then we start the second part. Then the floor is yours.
Yeah, okay.
Jeszcze raz witam, ja już w trakcie naszego
Okay, so during Marek's presentation, I did raise some comments of mine. Obviously, Marek's presentation was excellent, but it was given in a specific substantive and legal context, and Marek's reasoning was highly logical. However, I have several observations of my own that are more practical in nature, but only with regard to agricultural workers. So not individual farmers, but employees, workers employing agricultural workers, because we know that this company needs workers all the time, given the shortage of human resources in Poland. Let me start with a general comment. Currently, we are missing about 1 million employees only in agriculture. And I'm referring to agriculture in general, as broadly interpreted, but in particular soft fruit sector and the meat production sector. So let us clarify certain things. So Marek talked about unqualified workers in agriculture, but it's not exactly true, because let me tell you what it looks like from practical perspective in agricultural companies. Agricultural companies have huge problems with recruiting qualified workers who can use complex agricultural tools that are now available. Okay. So what we've been observing now is that large agricultural companies that have tens of thousands of hectares of farmland, they can't use their own advanced machinery because the old workers retired and they have problems recruiting qualified young workers. So they are resorting to specialist companies that are working the land for them. So it's a sort of inconvenience. But agriculture is not the same as a few decades ago. So it's not a worker that has simple tools in the field. We have machines that do the job to ensure profitability of agricultural production. It's about large surfaces of farmland and very complex agricultural machines. Well, I would not select a person who has only driven tractor before to drive a very complex machine that costs tens of hundreds of or rather hundreds of thousands of zlotys. Now, Marek has also told us about the fantastic experiences regarding joint inspections in agriculture. Let me tell you what it looked like with regards to spraying the land. At the beginning of this century, we have introduced certificates for machines that spray the land with herbicides or other kind of substances. So these people had to go through a training and receive a special certificate related to the use of these substances. And we had a new authority, which is the inspection created to control such seeds and products. And to improve the quality of such control, the legislator established that such inspection of farmland will be carried out jointly with police. And the result was a complete fiasco because police said, well, they will not run around the fields of, following tractors. So right now we do have certification and supervision, but no compliance because the joint inspections didn't work. Let me move on to the next issue. So temporary work agencies, also in the context of posting. In Poland, posting in this sector is completely marginal. Well, when Marek was speaking, I confronted the offers of job agencies, and I also consulted Pracuj.pl, which is a popular platform for job seekers, and agencies offer qualified workers for agricultural work, and at the same time, thousands of farms need workers. So on the one hand, there is this discourse on the part of agencies, and on the other hand, we have the demands of the labor market in the sector. We know that we have some data from our agricultural insurance institution that show us a large prevalence of temporary work. These concerns the citizens of Indonesia or Nepal. There is a new form of insurance. In 2006, we have the so-called agricultural assistant and CRUS, so the agricultural insurance institutions collect such data. But last year, we had only 2 workers from Nepal, 28 workers from Vietnam, and a little bit more workers from other countries. So about 50,000 workers that are insured. I will not go into detail. Let me tell you that it's a completely marginal issue. So once again, the legislator had a specific intent, but the reality looks completely different. The legislator knew very well that workers are needed, but introduced certain mechanisms that simply did not work out in the context of our agriculture. Also in the context of individual farming, because this is where farmers' assistance can be insured. Well, we can talk about Portugal, we can talk about Germany, we can talk about Spain, you know what the situation is there. In Poland, as regards insurance, we have a special institution for insuring farmers. It's a fairly widespread solution, but in 2016, we introduced this status of an agricultural assistant. So a farmer can sign a contract with this assistant. They must insure this assistant and provide them with health insurance and accident insurance, but such person is not governed by the labor code. So all disputes are settled on the ground of the civil code, which is surprising, shocking, because once again, we introduced the concept of a 19th century agricultural worker, yes? So there is no annual or rather hourly wage. So this proposal was meant for workers from the Far East initially, but it is used more extensively in reference to Poles. In this way, a neighbor who wants to earn some extra income has access to insurance. So we cause such a legal complexity that the person who is insured with this agricultural insurance institution, they may insure their own neighbor as a farming assistant. So the situation is absolutely ridiculous. But you all know that the legislator can adopt any law that they wish. I can say that these solutions have ended in fiasco, even though there are tens of thousands of people who take advantage of this insurance, even though it gives you nothing, practically everybody has access to health insurance in Poland right now, so it makes no point. And finally, there's one more thing I would like to disagree with Marek on, and that was the statement that the collective agreements are irrelevant. Yes, from the context of your speech, it was what I actually jotted down, or you said that the importance of these contracts is minimum. Actually, all agricultural companies in Poland, at least these companies where our trade union is present, we have collective agreements. They were signed in the 1990s and they are being updated on an ongoing basis. And let me tell you, without these collective agreements, we would have only minimum wage. We couldn't negotiate any terms and conditions of employment. So in our sector, collective agreements play an important role and they work. And in Poland, every single collective agreement is being registered. So on the basis of this collective agreement, you can raise some reservations, you can report the employer to the labor inspection, and the labor inspection cannot refuse to investigate your claim. Yes, so it works. Collective agreements work fine. And as regards other union tools such as a collective dispute, I will not talk about it because obviously it doesn't work that well. Thank you very much.
Dziękuję bardzo, Mario.
Thank you very much, Maria. I will be very brief. First of all, I'd like to say that for me, this project means a huge opportunity, an opportunity to understand better the reality of posted workers and migrant workers, because the reality for them is dire, and they need to function in that difficult reality in the European Union. This, I'm saying it as it is. It's difficult, it's demanding for them, it's challenging, and we should all be ashamed that they are placed in such dire circumstances. Let me give you an example of what happened in Portugal, very close to where we are now. In the south of Portugal, on the coast of Alentejo, so actually in the southwestern coast of Portugal, there were some Bangladesh workers and workers from places which are close to Bangladesh. So they were there undocumented. I'm not saying they were illegal. I don't want to use a word illegal worker because there is no such thing in the light of labor law. We have citizens in the world who simply work, and their situation may be unregulated and they are never illegal. And in this part of Portugal, the network of human traffickers was destroyed. What they would do is they would bring people to Portugal to pick the soft fruit. We all love soft fruit, raspberries, strawberries, and the companies that sell those fruit to us, which we love, want to sell these the fruit cheaply, and it comes as a cost, and the cost is the abuse and exploitation of humans, and this is actually a crime. We should be speaking about crime. They are placed in inhumane conditions, these workers. They sleep in very poor, shabby buildings of those agricultural cooperatives. There was an example in which people were simply housed in a metal container. And these people would sleep in a very small confined space. So let's say 10 or 15 people per one container. Pedro, what are you saying? My colleague is just telling me that there were no sanitary facilities. It was a shocking situation. It is very impossible for us to accept. Remember, it happened in the EU. And this was one specific example I wanted to give. I am myself not a lawyer. I'm not well versed in laws. But Pedro, my colleague, will tell you about the current laws applicable in Portugal. A few days ago, in another meeting, I said there are multiple regulations. I don't know if it's a good thing or not. I think that the fact that we have so many pieces of law, acts of law, and a lot of legislation means nothing. These regulations must be good, must protect the workers, must regulate the competition between companies. And first of all, the laws must be applied. They must be complied with. What's the use of a big book of laws if they are not applied in real life? And this is one fundamental issue I wanted to speak about. But there is one more comment I wish to make. Member states indeed have the right to design their regulations as they please. But at the same time, the European Union, or precisely the European Commission, has certain guidelines for migrant workers and should have certain guidelines and regulations that apply to migrant workers and posted workers. The Commission should put into effect regulations that protect these workers and offer them higher salaries, more favorable salaries. We should not allow Wild West to happen here. One thing is for the liberties and freedoms to apply, but the worker must always be protected. Because right now, unacceptable things happen, things that are contrary to European Union principles and freedoms. There's one more thing. Collective agreements are of key importance here. This is because the minimum standards are set in such collective agreements, such as remuneration or your rights at work, minimum salary which you offer, and you cannot go lower than that. Collective agreements play an important role in regulating the competition on the market as well. It is thanks to the collective agreements that employers, when they recruit staff, they would never do this on the black market because there are collective agreements in place. So they cannot offer a lower salary, they cannot blackmail or retaliate against workers that speak up about some irregularities. Right now in Europe and in the European Union, we found ourselves in a completely new situation and we are facing new challenges. And we should all be sensitive to human fate. We are speaking about humans here, not about goods or services. Workers are people, and that's the main message from my speech.
Angel, first Angel, then Arthur, then Alexandra.
Okay, gracias, Marek. Voy a intentar ser muy breve.
Thank you, Marek. I just wanted to give you some information about Spain. Of course, I will tell you more tomorrow. Right now, in Spain, there are a lot of posted workers. We are the third biggest country in terms of the number of posted workers. And there will be more people coming. And as Marek said, 23% of posted workers are people from third countries, so citizens of third countries, for example, from Morocco or from South Africa.
And there are more people coming to work in Spain than in the previous years. There are more than 70,000 of such workers. I believe we are the 8th country in terms of the number of workers coming to Spain. And I think that this number is at odds with the number of PDA1 documents issued, because there is no single register or system in which all the incoming people would be entered. And when people leave Spain to go work elsewhere, then we have some data about that. But the people coming to Spain, we don't have very specific, concrete data. Okay, I think that Marek wanted to say something else. I don't think that collective agreements are not effective. There was a directive in 2018 which regulated collective agreements, but there is a problem with that. There are some new countries in the European Union which do not have the applicable regulations for collective agreements to be effective. And if these collective agreements are not equally effective in all member states, that's not good. I think that Spain is one of the most advanced countries as far as collective agreements are concerned. They work really well and they are quite effective. Our collective agreements stipulate that actually the employer has two types of obligations. For example, the host country must provide the same remuneration and the same working conditions as the local workers. And when our workers go abroad, they simply have to be paid not lower salary than they would be paid in Spain. And all the workers coming to Spain are covered by the collective agreements. So the employers do have that obligation. They do not always comply with it, but it is indeed true that all workers in Spain are covered by collective agreements. We were already talking about this possibility of including migrant workers in the scope of our project, because it's difficult to understand the situation of posted workers without referring to migrant workers. Marek has given us some statistical information, and I believe that we should definitely include migrant workers within the scope of this project. In Spain, we have 500,000 of migrant workers whose situation is not regulated. There was a proposal of a bill in Spain to regulate the status of migrant workers, because we cannot simply remove them. We need them. They perform a lot of jobs which are necessary for our country. But what we must do is we must regulate their situation, their status. And we will be defining some protocols to do that. Our colleague from Poland also stated that there are some people taking care of others, and they perform work at people's homes, private homes, and the labor inspector, in order to perform an inspection, would have to visit the private home. And that's why we need some changes in the regulations, changes in the rules. So this all needs to be reviewed. Thank you very much.
I want to add to the very important issues to that. The colleagues from the Portugal side, actually the law have to be alive. Because what is the law? The law, this is the book. And books themselves, they not take the action. This is just the book. This is the law. Very nice. And what else? And this is very important at the law, it will be alive. And from our side, from our practice and experience, our members, the mostly is from the Central European Union. But for example, we have also members from the East Germany, or no East Germany, but previous East Germany and Germany. And for example, the employers in Norway make some calculation according to the workers from abroad. If we have, for example, postponed workers, we have migrant workers, and for example, we have the workers that are working in the rotation. And how the employer in Norway they can have a bad intention, how they calculate. The workers from abroad don't know the language, don't know the rules, and don't have enough money to enforce the law, to execute the law. And for example, when they go into the trade unions, this calculation go away because we know the language, we know the law, and we have enough money to go to the court against employer when they broke the rules. So I think this is very important. That's Grzegorz said, and the colleagues from Portugal at the collective agreements. And when also the trade unions looks on the case, because without the enforcing the law, it's happening nothing actually. The law it will be just that. Thank you.
Ja bym się chciała odnieść do...
I'd like to say something about temporary workers who are employed for agriculture. And there are very few efforts made in that area. Why is that? In order to hire a posted worker in Poland, you have to fulfill the minimum conditions that are stipulated in the laws, in the acts of law. And as Grzegorz said, there is no minimum wage in agriculture in Poland. And the other thing is that you have to pay contributions to social security, which are not low. And in agriculture, the level of contributions is different because they pay to a different institution. And there is a huge difference in the level of contributions to the social contribution and the amount of benefits that the workers receive. So if I wanted to hire someone for a very short period in the agricultural sector, I would have to actually not make money on this. I would have to lose money on employing this person. These are the conditions. And an employer who would want to employ such people would simply go bankrupt, or the temporary work agency would have to pay the employer extra money. And also the agency would have to provide workers with accommodation, which is not easy in the rural areas. And it often happens that workers can be housed in facilities which are not fit to house humans. For example, an old shed or just a shabby building. And this often happens, unfortunately, especially with companies that consider themselves to be a temporary work agency, but they are not registered in any official list of such agencies. And unfortunately, this happens in Poland. And they do offer people, they hire out people to farmers, and then these workers are exploited. They work in really poor and inhumane conditions, and they receive salaries which do not allow them to support themselves. It's a very, very poor salary. And these people are actually not employed. They are shareholders of a company. They don't need a work permit. They don't need to legalize their stay, and they receive a salary which is not regulated in any act of law. And this is something I wanted to add, and this happens in the agricultural sector. Speaking about our project, I remember that we recently participated in a project dedicated to posting in the care sector, and we together came to the conclusion that posting of workers to EU member states is a bit problematic because it's difficult to access reliable information at a single point. Of course, the governments do provide information about posting and what conditions you need to fulfill, but you need to search really well to find that information. So I am very hopeful that our project will fill in that gap and that we will be able to create, even for the participating countries, a special platform that will state all the conditions or will include a simple checklist. For example, if you want to post someone to Germany, then you need to do this and this and that. And then if you ticked off all the bullet points, that means your posting is legal. And I'm very hopeful that we will be successful in doing that, that we will create a single platform with all information, which will remain for good in the World Wide Web, and which will be updated, and new countries will be added, which post workers or to which workers are posted. Thank you.
Ja tylko chcę uzupełnić troszkę mojej koleżanki tutaj wystąpienie.
I just wanted to add a few things to what my colleagues stated. An average size of a farm in Poland is roughly 10 hectares. And if you want to insure an entrepreneur in Poland, you have to pay 2,500 per month. And if you want to insure a farmer who has up to 50 hectares, it's 609 zlotys per quarter. And roughly 90% of benefits paid out to farmers come from the state budget. That means that actually not many people pay contributions, but a lot of people draw the benefits. Roughly 11% of people actually do pay the contributions in the agricultural sector, and the state is actually losing 25 billion zlotys every year on benefits. Thank you very much.
Before I go defending myself, Susanne.
Yes, it was very good to get this feedback from everyone, because I think it also helps us to have a little bit more discussion instead of maybe going home and having not know so much what everyone is doing and what is seeing in the country. I just had a few practical questions. Maybe we discuss them also later, but I also wanted to react to what was said. Firstly, you said this morning, you talked about the Seasonal Workers Directive. There's, of course, other legislation versus the Posting Directive. So maybe you can also elaborate later or tomorrow on how we are going to look at both, or what else are we going to look at EU law related to the directive. I was also wondering, because in the CARE project, we had a lot of focus also in some countries on Ukrainians. I think it's still very relevant also to look in the different countries whether we see an increase of Ukrainians being posted. Maybe we could even agree to have some focus on that, because I think it would also be very interesting for us to see, because we hear this in the Netherlands and in other countries. As for looking at the exploitative practices, this is our daily business, and I do very much agree. We hear the same from all our members all over Europe, the very poor practices, the misuse of not only this directive, but also other labor legislation, and also that it's just on paper and not in practice. And I was just wondering a little bit, what are we doing? What I missed a little bit with that information, what I missed a little bit with Postcare 1 and Postcare 2, that we had a report. The report was finished after the project. There was not really anything done further with the project, with the report, to my knowledge. So I think, maybe we could also try to have this project a little bit of some advocacy together, some useful documents, maybe not very big reports, but some clear recommendations on what we see, also to those responsible for the posting directive, what we see and what should not work. And then lastly, about addressing labor exploitation is very, very difficult. We have a court case already for 4 or 5 years now related to North Korean workers exploited in Poland, where Dutch companies profited from it. We're probably not going to win that, but I see from a daily level from our members, it's very difficult to hold companies and employers accountable. Very often it's a violation of labor law, and then indeed, as we heard, companies go bankrupt and we don't hear more. So that's very, very difficult. And lastly, I was also wondering a little bit, how critical should we also on that question on labor shortages? Because the agricultural fields and all the fields have changed completely. When we talked about care work, it was very clear that the workers who were coming into a country would then deliver care services for that country. When you talk about agriculture or manufacturing work and other sectors, you also see that those companies grow and grow and are starting to produce a lot of products also for other countries. And I think they will never, I mean, that's my skepticism, they probably never have enough workers because it's profiting and they want to grow and to grow and to grow. So I just wonder how critical or how much we also touch upon that topic. Maybe it's a bit too much out of our field, but I think we have to be very critical also in this project.
Anyone else would like to take the floor? Artur, again.
I want just to add, I know this case from Poland about this North Korean employees. It was in, I mentioned, in shipyard in Szczecin, yes, and it was a little bit in TV. So, yes. Oh, okay, excellent. Yeah.
I start from the back. When we speak about North Korean workers, I had an interview with the labor inspector in Krakow, who has discovered 20 Korean workers at the building site. And of course, they were living in inhumane conditions, in a container indeed. Or 2 containers. It was not that bad. And they were asked to provide each of them was asked to provide a bank account number that their remuneration can be transferred to. And guess what? They all provided the same bank account number. And the inspector started to question them one by one with the help of interpreter. Are they treated well? Are they happy with the job? And you have never seen more happy workers in the world. The truth was that their family members back home were basically held hostage of their well behavior when they are working in Poland. And at the end of my interview, because this was part of the research, this inspector said, I really had a ethical problem with holding this employer liable for illegal employment or for not transferring the remuneration to actual workers, which is, of course, a crime because you don't pay the remuneration. But because of this, not double, but triple, quadruple standards that were applied there. Because by executing the law, which is normal thing to do when you discover the crime, you harm these people. And it's a similar problem from ethical point of view, like do you buy soft fruits or not? Because one way is to decrease demand. If we all know that soft fruits are blooded with the blood of the exploited workers, don't buy them. Don't buy Nike shoes because they are manufactured in Far East with blood and sweat of child labor. And of course, we all have this dilemma. We have the privilege to get the information that there might be something wrong in the process. But think of all the products that you are using today that you have no idea about the working conditions of the workers who created them. So one thing that certainly we will all agree about, and this is one of the most important conclusions that I take from your discussion, because Mario said this, Arthur said this, Alexandra said this, that we do not really have problems with the wrong legislation. The legislation which tries to solve the collisions of legislations of the member states is complicated, but it is good. The problem is with execution of this law. And unfortunately, what our governments usually do when they cannot execute law, they change the law. They change those rules. They think that the new rules will be better. And the revision of the Posting of Workers Directive did exactly this. It did nothing. It only complicated the process even more. And the more complex are the rules, the easier it is for the shady businesses to go under the radar because they are not executable. So what we need, I believe, is simpler rules and not more law, not more complicated law. But of course, these simpler rules will also do no good if we do not execute them. So I would put more hope in the enforcement directive than in the revision directive on posting of workers, where labor inspectorates did receive the tools. Not only labor inspectorates, but also social partners did receive the tools to monitor the working conditions in the receiving member states. So also monitor working conditions according to the legislation of another member state. And this is the barrier. I mean, if I was a businessman and I knew about it, that the Polish labor inspection is not allowed to check whether the remuneration I'm paying is in accordance with the foreign law. And if I knew that the German labor inspection is not allowed, or Zollamt, the more accurate body, is not allowed to enter for the control to the private households where my worker is carrying out work, I feel inclined to make use of it, to feel safe. And so if I may formulate this conclusion, we need better law execution. And indeed, it is also in the interests of service providers, of the companies who exercise freedom to provide services. The problem is that when you are an inspector and you have a register of posted workers, and only legally posted, lawfully posted workers are registered there, you send the control to a business who is legitimate, who are compliant with law. You do not send the control to unknown place where unknown, unnamed workers are carrying out work under the shade of private property secrecy or something like that. So this is also, I don't know how to solve this problem, but this is also the problem of very practical behavior of control officers. And last but not least, I must say that I didn't mean to underestimate the value of the Polish collective agreements. Absolutely not. I was putting it in the context, comparative context with Scandinavian countries and Nordic countries. And actually, Mario helped me understand my mistake or misunderstanding with Grzegorz, because you rightly said that in Portugal, collective agreements are about basic conditions, minimum standards. Whereas in Poland, the minimum standards are laid down in the labor code, and when you negotiate labor conditions in collective agreements, you cannot go below these standards. And because labor code regulates every tiny detail of employment conditions, the negotiating power of trade unions is structurally very weak. I show you the example. When I'm negotiating with you across the table, and you know that I cannot go down from my demands, because going down would mean going below the basic minimum conditions laid out in law, which is prohibited in the Polish labor code. What is the negotiating power of mine? I mean, employer organization or employers know that the trade unions cannot offer giving up anything in order to winning, to getting something in exchange. So for instance, we have temporary problems with selling our products because there is a crisis. Let's freeze the remuneration, or let's, on the contrary, we have a big contract which may help us with gaining new markets. Let's refrain from getting paid holidays in full now. Let's leave the holidays for the next year. This is not possible because it's a minimum standard below which you cannot negotiate. And of course, I'm not undermining the role of collective agreements. I'm just saying that in the Polish legislation, it is structurally constructed in the way that the value or for shaping the labor market and the working conditions, the value of the collective agreements is much lower than in Scandinavian countries or Portugal, where you can basically regulate everything in the collective agreement. This is not possible in Poland. And I absolutely agree with, and I wonder if this is only a Polish phenomenon, that when it comes to agriculture, we have this division between a farmer who is insured basically under the state system. His insurance is in 93%, to be accurate, financed from the general budget. Only 7% of the cost of benefits, social security benefits for farmers, comes from their contribution. In case of employees, it's the other way around, or even more, because the deficit in the social security fund is less than 4%, which means that 96% of the benefits are actually financed through the contributions, and only less than 4% is co-financed from the budget. this, because it's a structural thing, it's not economic problem of the sector. It's, as you said, it was laid out in the early 90s, and it's a structural thing. We have decided that the farmers will be insured from the budget and not from social security contributions. And now when we have these patches on the system and introduce the insurance for assistance of a farmer, of course, it's by definition it is a wrong solution, because neither these people have insurance. They don't have full insurance. As you said, this is only two risks: the health insurance and the accident insurance. So they don't gain the pension rights, for instance, and nor they are getting the proper social security elsewhere. So yes, we have a subcategory of workers, but what bothers me most is that you discovered it, that the intention of the parliament was to address this solution to foreigners mainly. So we intentionally wanted to create a second category workers from social security perspective, and we want them to be third country nationals. Oh, come on, this is 20th century, well, 19th century solution, 20th century too. So I was very surprised that it went this way, and I'm not surprised that most of these assistants of farmers are actually Polish, because of the thing that Alexandra said, that when you are temporary work agency, you can only apply labor contract or civil type contract, but still, from social security point of view, you pay full social security premium. Whereas when you hire an assistant or you are a farmer, your premiums are much lower. So the cost of labor is 50% lower, basically. So until we solve these internal problems, we will have this division. Well, if I knew how to do this, I wouldn't be here with you. I would be doing this. I know how to do posting. Of course.
Nie chciałbym tylko, żeby nasza dyskusja...
Well, I wouldn't like our discussion to focus on the job market in Poland. Well, it's moderator's fault that we are talking about Poland all the time. But I wanted to comment once again on the situation. Well, we are approaching the situation of agriculture from the perspective of individual farmers. And in 1990, farmers were covered by social insurance. There were 3.5 million of them. There was a lot of unemployment and nobody had any idea what to do with them. In the past, we had a lot of state-owned farms in Poland. These farms employed more than 1 million workers. And once they were wound up because of the market transformation, these farmers started their individual activity, and we had as many as 3.5 million of them. So the contribution level was set at a very low level, but the contributions remained low today. So we are still keeping these low contributions for a large but shrinking group of individual farmers, and we refuse to make these contributions realistic. Why? Well, farmers also vote, and they are unstable voters. Nobody wants to touch this topic in order not to lose these votes. These voters are very strong. They are united. We remember the Samoobrona self-defense movements. They could block the roads. They could take out heavy machinery and paralyze the entire state. So after these experiences, the politicians have left this issue aside. Maybe somebody in the future will deal with it. So yes, Marek were right to point out it's only 7% of benefits that are being financed with contributions. But it is true, but we have yet another fund that pays out short-term benefits. So let me comment on the strength of trade unions in different countries. I don't know what the unification rate is in other states. I know it is pretty high in Norway at around 51%, as far as I remember. In Norway, it's 68% on average, yes, so it's even higher. But in Poland, it hovers at around 14-15%. So we have a special law on trade unions that was adopted when trade unions were much stronger, with a trade unionization rate of about 28%. Yet at the same time, trade unions are expected to be highly active in terms of protecting workers' rights. And finally, it is the specificity of our Polish reality that trade unions represent all workers, regardless of whether they are trade union members or not. So we are facing a true paradox that a smaller and smaller group of people need to fight with employers and with the legislator in the matters that really are overwhelming, given our reality. Thank you very much, and I promise not to speak anymore today.
But let's not talk about Poland too much. Yes, but let's also recall ourselves that we're talking about cross-border situations. So referring to what Angel said, I agree we need to extend the scope of our project to migrant workers, but of course the Commission will not pay for this, not in this project. But what I think is needed, and I also spoke about it with Effie and Susanne during the break, is that we are not really able to determine the legal status of a worker when we find one. Well, let's go around this hotel. Let's go around the beaches surrounding the hotel. There are foreign workers here. I'm sure we can find one. Now let's make an exercise in the afternoon. Find a foreign worker and try to determine. No, seriously, try to determine what is his legal status. Is he employed by a Spanish company? Is he employed by perhaps a Polish company who posts this person to Spain? Or is he undeclared worker, or is he registered? And if you cannot find a foreign worker in the afternoon around, ask yourselves, did you come here with your portable document A1? Not you, Angel. You don't need portable document A1 to work in Spain. And you guys are also from Spain, Laura, Natalia. You don't need portable document A1. But those of you who are not from Spain, should you have portable documents A1 from your social security institution or not? Well, in case of Norway, it would be portable document E101, because it's still an ancient version of the document. And I know that we are all here on a business trip, or I guess that we are all here on a business trip. So from the labor law perspective, our remuneration for today's work may differ, even though we are doing the same work in the same place. Come on, where is equal pay? But because we are on business trip, the remuneration may differ. We are not sent here on behalf of our employer to do the service to a service recipient. But we are all sent here by our employers to perform work on his behalf, in his name, which means that from social security point of view, we are posted workers here and now. So who has the portable document A1 with you? Hopefully nobody. Because, as I said in the beginning, Social Security follows you even without the documents. That's the beauty of the coordination of Social Security. But I think it would be really interesting to make this exercise, find a foreign worker, preferably speaking your own language. And so in my case, a Polish worker, and try to determine what is his legal status. And if we can wrap up our discussion today with information deficiencies, I think if we had an easy mechanism based either on simple notification or portable documents A1, because these are the two formal documents that need to be in place and that the Tribunal of Justice of the European Union said that are not an extensive barrier towards freedom to provide services. So it is legal for each member state to demand the registration, the simple registration of a posted worker. When we are discussing the information deficiencies, at the same time, the Commission is working hard on unifying the registration systems all over European Union. This will never happen because Belgium has created their Limosa system as the first member state for registering all kinds of work mobility, not only posting, all kinds of work mobility. And they are very proud of it because the data that is entered to this system can be entered by anyone. It doesn't have to be employer. It can be also a worker. But this data is then conveyed to 52 different control institutions for various aspects, not only labor inspection, in order to reveal some inappropriate behavior. And if on the labor market, and if the red lamp goes on, they send the control institution to the exact place where it is. So they are not completely blind in the process of control. And they will never give up this system in order to introduce the unified European system. The same goes probably for CIPSI in France and Melde Portal in the Netherlands, which is a fresh instrument, I think, for 2 years now. And it also plays a very similar role. But from the perspective of the service providers, of enterprises, it would be really nice thing to have a unified system, preferably European system, where the only variable would be the country you post your worker to. And all the other data would be unified, would be the same. It could even be stored in the system for future reference. Of course, there is data protection issues, but that would make the system more transparent, and probably that would make determination of the legal status of a foreigner in your country easier to do. There was one last sentence. I would never like to realize the idea that came during the discussion on the revised directive that posted workers should be labeled with a special vest, or they were even said about the band on the arm. So we're not going that way. We still want to know their legal status. Yes, Effie, I'm sorry.
No, I just, because I mean, on one hand, the registration is good, but on the other, we also see in the Netherlands that there is the registration, but there is, what they say is that they don't have enough capacity or money to actually ensure that the registration system is used to the good effect. So even those who, like American companies, will just fill it in while they cannot even make use of posting, etc. And it takes them more effort to take it out and to streamline the system. So, and I have the feeling that if there is no control on the system and no control on whether or not companies do register, even though it's mandatory, then, well, the effects, the positive effects are limited. That's just the downsides. And I would want, I hope that it would be more efficient than it is currently, at least in the Netherlands.
To answer this, I would like to say two letters, AI. This could be an answer, really, and sooner than we expect. Artificial intelligence will, to some extent against our will, make it possible to basically geographically track a person. I mean, the systems already do this. Facebook does this, Google does this. The difference is that what I'm talking about is that the government does this. You know what's the difference? The difference is that when you clicked the general provisions of Facebook creating your account, you voluntarily agreed your phone to be connected to the system. So Facebook exactly knows not only where I am, but what I'm doing here, that I'm here on a conference. They know this. I gave them this information myself. The problem is that and it's a private company established somewhere far away on another planet called America. But if we do the same power to the governments, they may and they will abuse it. And that's why the control, there is a difference between the voluntary control that you can give to the private company voluntarily and the government control which would not be voluntary. So we are a little bit scared about going this as far as, you know, wiring those devices to the government portals. But yes, they would know, and also it would be a robot who would process this data. So we wouldn't have to hire so many inspectors. We would only send inspectors to the places where there is I don't know, too many of those foreign devices, or that they are connected to a metal industry, for instance, or agriculture places, and that would be probably easier. But I'm not formulating this as a postulate, as a policy recommendation of our group. Unless you insist, then I'll democratically withdraw. Okay, I think we have 10 minutes left in today's, yeah, so last round. All right.
To ja jeszcze coś powiem. Ja na przykład jestem...
Okay, so let me add something. Well, I would actually be in favor of a system of notifying incoming posted workers, not because the state would be able to trace them, to trace their location, but I am perhaps naive that it would limit abuse, that companies that actually import workers, not only in Poland, would have to submit themselves to more extensive control. They would have to be able to show what kind of workers they have, where they work, and maybe these workers could work in better conditions on the basis of normal contracts and would have a chance to live normally, regularly, because there are many cases when people come to a country to earn extra cash and then return home. Unfortunately, before they return home, they fall victim of an accident, they are not insured, and unfortunately, they do not, in certain cases, go back at all because the accident is fatal. So I would like the system to support workers, but also partially companies, entrepreneurs, so that they could carry out their work reliably, so that they could comply with the law reliably. And I have a single general observation. Maybe it's a little bit aside from of the general theme, but the general level of consumptionism also contributes to the abuse of workers. Everybody wants to make the price as low as possible. Everybody wants to pay as little as possible and to get as much as possible. And this is why we have problems with compliance with the law.
I think this is very important what Alexandra is told. But in Norway, we call vaktbikkja. So the social partners is such like watchdogs. And actually, this is also mentioned in the post workers directive. This is very they need that the partners and public sectors will be cooperate and employers with the social partners. So the employees will be not the rules from the employees will be not broken. The law and the law code, the labor code, or so on, so on. So in Norway and in Scandinavia, actually, the most job in this area they are making the social partners. Of course, the labor agency also on they can aid some also supports.
I would love to enter into discussion with this because we have a very fresh case from the Netherlands. They have this organization called SNCU, and it's an organization which represents social partners in hiring out workers. On one hand, employers of the temporary work agencies, SNCU. Switch on the mic.
But the SNCU, maybe it's a different abbreviation because they monitor whether the collective bargaining agreements are implemented. But they don't send out workers.
Yes, exactly. They are. Thank you. They are monitoring the obedience of collective agreement for temporary work agencies active in the Netherlands, and the collective agreements in temporary work are also binding the temporary work agencies from abroad who hire out workers to Netherlands. And the problem is that the posting of workers directive, the enforcement directive, allows for certain set of data to be subject of control in order to determine whether it's a genuine posting or not. And it is very important for the functioning of the common market that we do not extend this set of data, that employers know what they have to present to the control institutions. And SNCU is demanding much more documentation than is the scope of the directive. Now, from the formal point of view, they are the social partner who is responsible for monitoring the employment conditions of the posted workers as well, not only of the Dutch workers, but also of the posted workers. The problem is that they demand more than is allowed by the Posting of Workers Directive. And so they play a very important role as a watchdog, as you said, but they go beyond the barriers that are, according to the treaty, allowed in provision of cross-border provision of services. So it's questionable, especially because they apply these extended data demands to foreign companies only, not to Dutch companies. So of course their actions, and because they also represent they are founded by employers and trade unions in the Netherlands, of course they represent the interests of the Dutch companies. So it's like an organization created by your competitor is demanding the vital data of your company, of the company who is competing with them. It's a questionable. I mean, if we had strict rule and stick to them, okay. But here again, it's the poor execution of the legislation, because the European legislation is there, and it says that there is a set of information that you have to provide. The contract with the worker, you have to provide it. The pay slips, you have to provide it. But not the social security contributions, for instance, which is one data too much. Well, I'm not neglecting again, I don't want you to have the impression that I don't appreciate what trade unions do for this civilization. I do. I'm just saying that it goes both ways, that we have to stick to the rules. Susanne?
Yeah, maybe just one comment. Is it correct? Yeah. Maybe just one comment on the consumerism and all that. I don't know if we could find this out, if with posted work and severe exploitation, then products and services are delivered. Because of course at the EU level, you now have the CS-DDD, the due diligence legislation, due to which there is more due diligence needed. But also this month, the forced labor ban forbidding products at the EU market, also within the EU, will likely be adopted by the Parliament. So it could be interesting also to make a link. I think that's far too big within this project. But if people talk about consumerism, that could be an interesting angle to say those products are made by posted workers, and those posted workers are severely exploited. As such, those products should be banned. Maybe that could raise some attention.
My comment will be bitter, because we already have in the European Union regulations on the obligation to track the chain of suppliers when it comes to products, but not when it comes to people. And indeed, you can have a Ukrainian temporary work agency who hires out workers to a Polish user employer who then posts this not even Ukrainian, Tajik citizens to Germany, and then they can be reposted to further member state. And this is the chain posting is legal and quite well regulated actually when it comes to EU citizens, but it is not regulated when it comes to third country nationals. And I think that that fuels your job. You have a lot of work to do in La Strada. I think we're coming to an end of our session, and I would like to say that tomorrow will be. Am I right that we are finishing at 2 today, Mario? We are finishing at 2 today. Yes. Sí. Gracias.
Yes.
Obrigado. So tomorrow we'll be talking about the information deficiencies on single national websites. If you could spot some in your member states. And also we will talk about the content of the deliverables that we have to deliver in this project. So tomorrow we'll be talking about the building the chat bot and about creating the video blogs and what should be the content of both of those instruments. Because this project is not a research project. It's more project focusing on information, on delivering the right information. So we start with information deficiencies tomorrow morning.
I have a question, just technical. Maybe we will take a common picture on the site and send around. Yes, it will be useful for the project.
I would like to thank the interpreters for their hard work and remote work. I wish you were here, but thank you again for a very good job. Thank you.